I want to say how grateful I am that I'm able to stand here and speak to you all after these last few weeks. Things have not been presented exactly chronologically, or I think in the easiest to understand manner. We've had video testimony. Sometimes that's felt out of order, out of chronological order. Sometimes it's hard to hear. It'd be hard for anyone to catch everything that's been presented. Myself, Ms. Krause, Ms. Renner, and most of all, Mark Jensen, are so relieved to have such an obviously attentive and serious group of jurors. So thank you for that. Now, I'm not going to yell and shout about penis pictures. I don't yell and shout about really anything. During this trial, we've tried to be measured and analytical. And that's how I'm going to try to approach this as well. Because this man is charged with homicide. And emotional appeals that cloud the relevant evidence is not what's needed. In thinking about all the things that have been presented and trying to organize it, the photos, the harassment, the penis drawings, that was a lot of it. How much of it is actually relevant to the prosecution's allegation that Mark Jensen committed first-degree intentional homicide? I think a lot of it is meaningless. A lot of it serves no purpose other than an attempt to establish that Mark Jensen had pornography in 2002 on his computer that the prosecution has a problem with. Throughout this time that I have, I'm going to try to focus on what Mark Jensen is actually charged with and the relevant evidence regarding it. You heard the judge read the instructions, and I just want to touch on one of those instructions. Because in America, when you're charged with a crime, you have no burden of proving your innocence. It's the government that has to prove it before you can be found guilty. That's because you can guarantee you won't commit a crime, but you can never guarantee you won't be accused of one. And you've heard this jury instruction of the level of proof that's required when you're accused of a crime, beyond a reasonable doubt. The jury instruction does a couple of things. First, it tells you what a reasonable doubt is, and then, in sort of a roundabout way, it tells you what beyond a reasonable doubt means. First, a reasonable doubt is, and you heard this, is a doubt based upon reason and common sense. The sort of doubt that would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. Pause or hesitate when called to act upon the most important affairs in life. What are the most important affairs of life? Is it buying a house? Is it choosing whether to trust somebody? Is it buying a car? If you're buying a house, at the home inspection you see a hairline crack in the foundation, do you pause or hesitate to have to need more information before you move forward? Because if you do, that's reasonable doubt. That's the standard in Wisconsin, and that instruction about the level of proof that the prosecution bears in this case before you can be convicted of a crime. What if you find out that your home inspector has a fraud conviction? Do you pause? So that's reasonable doubt, but what does beyond a reasonable doubt mean? First of all, it means nothing has given you any pause. But the instruction actually tells us what beyond a reasonable doubt means. It says you are not to search for doubt, you're to search for the truth. And that makes sense, because if you were to search for doubt, that would mean the defense carries some sort of burden. And we know that's not true. The entire burden is on the prosecution. It's the truth. Has the prosecution proven its case such that you're convinced its allegation is the actual truth? Because if there's something that gives you any pause or hesitation when considering the prosecution's allegation of what, when, where, why, how, that's reasonable doubt. And it's only when you can comfortably say there's no pause or hesitation that you can say that the prosecution has proven its allegation to be the truth. It's not guessing. It's not guessing at what you think may have happened. It's a careful analysis of whether the government has met its very high burden before a person in America can be convicted of a crime. Through the course of my time to talk with you, I want to talk about memory and how we all know how memories change. How they changed in this case. You saw that with witnesses testifying now, asked about their memories and what they testified to in 2008 and 2007, in 1998, maybe in 2002 when they were first interviewed by the investigators. How it was years before investigation even spoke to people in this case. How it was 9 years before some people even claimed they remembered anything. This trial has taken about 3 weeks. Wait and see when you go into deliberations if you all have the same memory of what each witness said. I want to talk about lies, because the centerpiece of the state's entire prosecution is a lie. And I want to talk about something called confirmation bias. Confirmation bias is when someone searches for and interprets information in a way that confirms or supports one's belief. It's not scientific. It's the opposite of scientific. It's not a process that results in a fair assessment of evidence. It's the opposite of fair. We see it in the states bending facts to science when it should be applying science to the facts. We see it in how Julie Jensen is described by the state. We see it in the systematic ignoring or pretending that certain facts just don't exist. We talked about things that cause you to pause or hesitate in the most important affairs of life. These are things that can cause more than just a pause. These are full stops. I want to mention a couple of things just out of the gate. There have been some, and this fits with what I've just talked about. There's this assertion that there's a high five when Mark came back to his house on December 4th. We talked with Detective Ratsberg at length about the handoff of that house on December 4th and the police that were there and all the observations of Mark Jensen. And you didn't hear anything about an observation of a high five and the timing of when this would have happened and it being late at night and how everything was being observed and recorded. This idea that Mark Jensen threw away her belongings. Now, I mean, I'm not going to be able to go through everything everyone said, and you're going to have to rely on your notes for some of these things, but the throwing away the belongings, when we dug into what does that mean, what was actually observed, very little. And very little knowledge or no knowledge at all about whether things were set out for a donation, what was in bags. Somebody recognized something that they thought may have belonged to Julie Jensen, and from that, this memory was created that, oh my God, Mark Jensen threw away all of Julie Jensen's things. Go back and look at what was actually said about that. He hated her, and that's what was going on. I mean, that's really, I'd say it's a lot more complicated. We heard just yesterday how Mark and his son were building a Christmas rod, a fishing rod for Christmas for Julie Jensen. Those day planner notes, and then combined with her later statements about how he's encouraging her to see a doctor. The investigation that was done in this case, even the things found in that office, the box of zip drives, nothing was fingerprinted. This theory, this idea that Julie Jensen never had anything to do with the computer. There's just very little investigation that was done in most of these things. They weren't looking for ethylene glycol. This idea that it was hidden, or what was Mark Jensen doing on December 3rd? They weren't looking for ethylene glycol when they searched the house. Detective Ratsberg acknowledged that. He said, when we looked back at the video, yeah, I could see things in the garage that looked like probably antifreeze. They took the Playboys. They didn't take the antifreeze. I need to spend some time talking about Aaron Dillard. Aaron Dillard, Aaron Galvin, Kyle Rezick. I don't know who this person is. He's an actual con man. He's someone who has conned educated people out of their life's savings. He's an international con man. And he's never stopped his lying, and he's never stopped his deceit. How does a con man convince people to buy his stories? He blends facts with fiction so that it sounds possible. He tells people what they want to hear. He presents himself as a reasonable, well-spoken individual. I think you saw that in here. You saw how he presents himself. In Lithuania, these families wanted visas to America, so Aaron Dillard took their life savings, and he did that 7 times over. Think of the things that Aaron Dillard was willing to do for a few $100s or a few $1,000s. He lied about who he was, he defrauded companies, he bought check stock, created false companies, false payroll checks. He researched how to be a medical and surgical equipment seller in order to defraud Wendy Reamer, who believed his name was Kyle Rezick, over and over again. You heard Lori Brown. She was a lawyer and then an administrator of a law firm, a smart, educated woman. She got defrauded by Dillard. She described him as personable, knowledgeable, and that he instilled a lot of confidence. Her opinion? He's not a truthful or honest person. How about Deborah Teagle Spears? She testified in this case. She met Kyle Rezick. She lent him money. Eventually, she went into his wallet to find out what his real name is and ran a check on him. Do you remember what Miss Spears said about Dillard when asked about his character for truthfulness? She said, he has no character. He's a con man. He uses people for what he can get out of them. So on August 14th, 2007, when Aaron Dillard got to the Kenosha County Jail, what was he willing to do? He had been out on extended supervision and was coming back to court to determine how long he was going to go back to prison. He was AWOL from supervision. He got pulled over on May 31st, 2007. At that point, he hadn't reported to his agent since the previous October. When he got pulled over and he had a suspended registration, he lied to a police officer and said he was his brother, Mike Kaiser. And then while claiming to be Michael Kaiser, he blamed the suspended registration on his brother, Aaron Dillard. This is what he does. The police figured it out and he got charged with obstructing an officer. He had 17 violations while out on probation. He had cheated Dennis Ritt out of money. He told Dennis Ritt that he had a telecommunications company in Lithuania. He convinced him to lend him money, never paid him back. He wrote a check from a closed bank account to Dennis Ritt, knowing it's not good. He had defrauded Lori Brown. He had defrauded Cassandra Ivey. Cassandra Ivey had paid him $6,200 and had a construction contract with Dillard. For that, he got charged with theft by contractor and home improvement fraud. Dillard was facing 7 years on that case. For the reconfinement, he knew that his probation agent was recommending he get the maximum time available of 4.5 years. And it was an aggressive recommendation. I asked Aaron Dillard this when he was testifying, and he acknowledged, he said he was aware of the probation agent's justification for the maximum sentence. And I read it to him, and he remembered it. It is obvious that Mr. Dillard is in need of serious CGIP, but his criminal behavior is well beyond the need of cognitive thinking. His repetitive, deviant thinking is just in plain need of confinement. Even though prisons are normally used for rehabilitative purposes, Mr. Dillard is in desperate need of incarceration. It is the suggestion of this document that persons with criminal behavior of this caliber show no guilt or remorse. Their goal in life is to be a successful criminal. They are motivated by the power they feel to manipulate others, sometimes for material gain. So when he got to the Kenosha jail on August 14th, 2007, he was facing 9 months on that obstructing charge, 7 years on the theft by contractor home improvement fraud case, and a recommendation of 4.5 years from his probation agent. What was Aaron Dillard willing to do for a few $1,000s? Ruin people's lives. And you've seen what Aaron Dillard was willing to do to get out of years of prison. When Aaron Dillard got to the Kenosha jail on August 14th, 2007, he immediately recognized Mark Jensen. He knew about him from articles, he knew it was a high-profile case, and within 30 minutes he was talking with him. That's how quickly Aaron Dillard found his mark. And what did Dillard claim? He basically talked nonstop with Mark Jensen about his case. The evening of the 14th, all day on the 15th, all day on the 16th. He said that Mark Jensen shared the transcript of the Klug hearing and then talked all about his case. He said that Mark protested his innocence all evening of the 14th. He said that Mark protested his innocence all day on the 15th. And then on the 16th, Aaron Dillard said, you know, we all did something to get here. And Mark said, yeah, and then gave him a full confession. Do you remember the 7-hour interrogation by Detective Ratsberg? You were shown 45 minutes of it. Highly trained interrogator. I guess if only Detective Ratsberg had said, come on, right? Aside from just how unbelievable this story is, the prosecution bought it completely. Dr. Mainland bought it. Dr. Chambliss bought it. Mark Jensen was charged in 2002 with homicide in this case. Then in 2008, after hearing about Aaron Dillard's claim, they changed their opinions. Dr. Chambliss went from undetermined to asphyxia by smothering. Dr. Mainland went from ethylene glycol poisoning to ethylene glycol poisoning with probable terminal asphyxia. Why was everyone so willing to be victimized by Aaron Dillard? I think it's because the science and the evidence don't support the theory that Mark Jensen killed Julie Jensen with ethylene glycol. I think it's because it makes no sense that if Julie Jensen was paranoid and not eating or drinking anything from Mark, that then she'd suddenly eat and drink everything he gave her. And according to Doctors Chambliss, Mainland, and the prosecution, where could Aaron Dillard have learned these details? We're not wondering that anymore, are we? On August 11th, 2007, 3 days before Aaron Dillard showed up, Mark Jensen received 2 oversized envelopes from his attorney. In those envelopes were the transcripts of Ed Klug and the interrogation of Mark by Detective Ratsburg. Now, you heard from Nathaniel Clanton. Nathaniel Clanton's time in J Block actually overlapped a little with Aaron Dillard. I think he said he got there on August 16th. Nathaniel Clanton explained how Mark Jensen handled himself in the jail. He said Mark had 2 bins of paperwork. Mark would freely discuss details and share that paperwork with other inmates. He'd share his police reports. He'd freely share his case files. Nathaniel Clanton explained that Mark would even share this with the people that were only there for a few days. And Nathaniel Clanton did more than that. He explained what an awful idea it is to share your information in a jail. People will use it against you. They'll take the information, they'll twist it, they'll add some lies, and they'll make it look like you're confessing to something you didn't do. Mr. Clanton explained that happens quite a bit in jails. When Detective Ratsburg interrogated Mark Jensen, he told you that he was trying to come up with different scenarios to get Mark to confess. Detective Ratsburg had the autopsy, and he was trying to make his scenarios fit what he thought were the autopsy findings. He testified to that. You heard Detective Ratsburg's imagined scenarios that he proposed to Mark Jensen. Her arm was actually here, I'll show you how she was, okay? Her arm is actually across her body like that, okay? And it's an unnatural position. Do you sleep when you're on your side with your arm across like that? I know there was some type of contact there. There had to be in the chest, this chest area, Mark. There's no question about that. And the only person that could have done that was you. I'm thinking before you left, you pushed on her maybe. Now, she was frail at the time. She was frail. You said she was labored breathing. That makes sense, and I believe that. Okay, I know that probably happened, but she's frail. And you just innocently, I don't want to, pushed her like that. And could that have caused something? I mean, we have petechiae of the lungs. There's some type of contact here in the throat. There's also been an indication on the throat, as I showed you in Dr. Chambliss's report. It just did not appear there. Something and somebody had to touch her. That's the only way it could get there. There's no doubt about that. And did you push her, touch her on the throat maybe? Maybe like this? Maybe when you brought her over this way, you pushed her back on the chest and then went back and brought her up again. You know, you would have pushed her back. We still have to explain the nose part, the head pushed into the pillow. How are we going to explain that? I mean, that's there. Something had to push it down. There's three things that happened here. Head being pushed, the nose, some type of contact here at the throat, and some type of contact here in the chest. We know that happened, okay? You were the only one there. You had to do something, Mark. Dr. Mainland acknowledged, testifying this time, that Aaron Dillard could have gotten those details that made up his claim from this transcript. She agreed that Aaron Dillard's claim was not found in the Klug transcript, but was found in Detective Ratsburg's claims in the interrogation transcript, and that those claims lined up with the autopsy report. The prosecution has insisted, though. They keep insisting. Aaron Dillard denied reading anything except for the Klug transcript. Well, his claim would be a lot less convincing if he admitted to making it up. Can you trust what Aaron Dillard says when a decade of prison is on the line? Can you trust him when $50 is on the line? Dr. Mainland said she wouldn't buy a used car from Aaron Dillard. Does Aaron Dillard give you pause? To me, it warrants slamming on the brakes and never wanting to engage with the man in any way. We have to look further because his story has some reveals. Look closely at it. He said that Mark wishes he hadn't opened his stupid mouth around his coworker about him wanting to kill his wife. That's what's fucking him now. That's what Aaron Dillard wrote. So the person who allegedly regrets saying something to Ed Klug while maintaining his innocence, while denying that he ever said anything to Ed Klug, would then open his mouth and offer a full confession to the person that you're saying these things to? That doesn't make any sense. Aaron Dillard says, on a Tuesday, he took her to a doctor. That's a small detail buried in his statement. But we know from Dr. Borman that Julie came alone to that doctor appointment. He first describes Julie Jensen on December 2nd as just throwing up a little. He then changes it to really just vomiting. There's no vomit anywhere. And when she died, her stomach was full. He says that Mark came home and that Julie Jensen was breathing better. But we learned from Dr. Hale, the only one who testified in this courtroom that was qualified to discuss ethylene glycol poisoning, the only toxicologist you heard from. As long as a person is still processing ethylene glycol, they'd be in phase 2. Their breathing wouldn't get better. They'd be trying to get rid of that, to blow off that carbon dioxide. And because Detective Ratsburg isn't a forensic pathologist, he proposed an asphyxiation death, but didn't take into account that there were no marks or injuries to the inside of Julie Jensen's mouth when what's described is shoving her face into a pillow until she asphyxiated.